Hello students, I hope you are doing well. Today we are going to discuss another topic in the subject of Law of Contract 1. The title of our lecture today is Remedies for Standard Form Contracts. Let's start with the lecture. In the fast-paced, high-tech world of the present time, boilerplate contracts, or more popularly known as standard form contracts, are the dominant way of making commercial and consumer contracts. Purchasing a mobile, purchasing internet access, booking an aeroplane seat, or downloading an application generally involves the execution of binding contracts without negotiations. The contracts are usually prepared unilaterally by one of the parties, most often a service provider or a corporation, and then offered to the consumer on a take it or leave it basis. Their ubiquity in industries such as telecommunications, banking, insurance, and online services bears witness to their usefulness in enabling mass transactions on the basis of standard terms. Although the contracts undoubtedly serve essential business goals, enhancing efficiency, reducing transaction costs, and promoting uniformity, their ubiquity also raises inherent issue of fairness and consent. The foundation of the law of contract is the principle of free and informed consent. Yet, under standard form contracts, the disadvantaged party has no real bargaining power nor bargaining leverage. This leads to an inherent imbalance of power, which can culminate in the enforcement of unfair, one-sided, or even unconscionable terms such as extravagant liability limits, unjustified termination provisions, or coercive arbitration provisions in far-flung places. For law students, especially within the Indian legal system, it is essential to understand the legal remedy and remedies against unfair standard form contracts. Indian contract law, as formulated under the Indian Contract Act of 1872, has traditionally presumed equality between contracting parties. Yet, legislatures and courts have realized the need to provide remedies and protective maxims where such a presumption does not prove to be good in the case of standard contracts. This is demonstrative of growing sensitivity towards consumer protection, access to justice, and protection of public economic interests. The judiciary has exercised a robust role in reducing exploitation inherent in standard form contracts by invoking maxims such as unconscionability and contra proferentum, besides resorting to constitutional principles of reasonableness and fairness. At the same time, legislative interventions such as the Consumer Protection Act of 2019 and the Competition Act of 2002 have broadened the ambit of remedies to be extended to aggrieved parties. These remedies range from rescission or adjustment of unfair terms, such as the grant of damages to the aggrieved party, to prevention of enforcement of such contracts by injunctions. This lecture tries to provide an in-depth overview of the law of standard form contracts with remedies under Indian law, tracing their evolution and interpretation through court decisions. It will also provide a comparative overview outlining briefly how other legal systems have approached the problem and practical advice to students on the treatment of such contracts as future legal professionals. In the age of the computer, when technology moves at lightning speed and commercial practice evolves on a daily basis, examination of firms' contracts is increasingly needed. As consumers, users, and prospective authors of the same, it is of the utmost significance to adopt an informed view. This lecture thus tries to be more than the scholarly introduction, but an inducement to critical examination and consideration of one of the most pervasive yet less scrutinized legal tools of modern law. Now let us talk about judicial remedies and doctrines against unfair standard form contracts. First is doctrine of reasonable notice. This canon requires that any unusual or burdensome conditions of a contract must be notified reasonably to the weaker party. The pioneering English case of Thornton versus Shoe Lane Parking Limited set the stage that a party cannot be held to be bound by contractual conditions unless reasonable notice is given either before or at the time of entering into the contract. Indian courts have followed this canon ever since, particularly in airline, railway and internet contracts. In the case of Interglobe Aviation Limited versus N. Sachidanand 2020, the Supreme Court of India held that the terms and conditions of an airline contract could not be enforced unless these were brought to the notice of the passenger in clear terms. Posting terms on a website or ticket with insufficient prominence was found to be unsatisfactory. This judgment made the requirement of clear notice of contractual terms more stringent so that consent is truly informed. The next is the doctrine of fundamental breach. This doctrine states that a party shall not be able to invoke a limitation or exclusion clause if it has breached the contract in a fundamental manner. That is, where the very nature of the contract has been breached, any protective clause intended to benefit the party in default loses efficacy. In Bharati Knitting Company versus DHL Worldwide Express Courier Division 1996, the Supreme Court invoked this principle in the case of limitation of liability clauses in courier agreements. Although the court sanctioned contractual limitation of liability, it did so subject to proviso that such clauses must be clearly set out and must not unconscionably exempt parties from their basic obligations. Indian jurisprudence has therefore proceeded with great caution in applying the said clauses to principles of good conscience and the pursuit of justice. Next is the doctrine of unconscionability. The doctrine of unconscionability applies to contractual terms or conditions that are unduly one-sided or oppressive and thus shock the conscience of the courts. This doctrine has become extremely significant pursuant to Indian law, especially in employment, insurance and consumer contracts. In the LIC of India versus Consumer Education and Research Center 1995, the Supreme Court held that a life insurance policy excluding medical coverage for specific classes of employees was arbitrary and against Article 21 of the Indian Constitution. The court reiterated that contract terms should be consistent with the principles of fairness, equality and social justice. This judgment represented a shift from the classical freedom of contract doctrine to a welfare-based doctrine, especially where the weaker contracting party has no option. Similarly, in Pepsi Foods Limited versus Bharat Coca-Cola Holdings 2003, the Delhi High Court refused to enforce an arbitration agreement that disproportionately burdened a party without bargaining power and held it to be unconscionable and against public policy. The next is contra profertum rule. The contra profertum maxim is that any doubt in a contract should be construed against the interest of the party who drew up the document. The maxim fits the case of standard form contracts best, in which one party typically draws up the terms. The maxim has always been applied to insurance cases. In United India Insurance Company Limited versus Pushpalaya Printers 2004, the Supreme Court held that in cases where an insurance policy was ambiguous, the most reasonable construction to the insured should be used. This is meant to discourage companies from employing ambiguous or uncertain language as a means of avoiding liability. Next is Public Law Review and Article 14. State instrumentalities agreements with public authorities are subject to constitutional examination under Article 14, which enshrines the doctrine of equality before the law. In Central Inland Water Transport Corporation Limited versus Brojo Nath Ganguly 1986, the Supreme Court ruled that a unilateral termination clause in the absence of notice or reasonable cause was arbitrary and against the spirit of Article 14. The court declared the said clause to be void as it was against public policy and justice. This judgment widened the ambit of judicial review of agreements between public authorities, reaffirming the doctrine that even transactions based upon private law must meet constitutional criteria where a state agency is a contracting party. It enunciated the doctrine that fairness is not only a procedural but also a material requirement, particularly where there is a gigantic imbalance of bargaining power. Now let us talk about statutory remedies available under Indian law. Statutory measures to counteract the imbalances embedded in standard form contracts in Indian law are mainly shaped through a sequence of landmark legislations. Such legislation is designed with the objective of protecting individuals from the adverse effects of unfair or discriminatory contractual terms, more particularly in the context of consumer and commercial purpose agreements where there exists inequality in the bargaining power of parties. The key legislation in this regard is the Consumer Protection Act of 2019. The Act clearly recognizes the possibility of exploitation embedded in classical contracts and ensures effective redressal mechanisms. Consumers are safeguarded and entitled to object to any unfair contractual terms, more particularly those likely to result in material detriment or constitute unjustified prejudice. The Act has listed such unfair contracts as those requiring unreasonable security deposits, containing excessively penalizing terms in case of default, or providing for unilateral variations of terms by the service provider. Consumer commissions at district, state and national levels are authorized by the Act to declare such terms to be void and grant compensation or injunctive relief. The Central Consumer Protection Authority also has the investigative power to start action against false representations and unfair trade practices in respect of such contracts. The remedies create equilibriums between contracting parties and deter service providers from exploiting their superior bargaining position in contractual transactions. The Competition Act of 2002 enforces its provisions within the framework of abuse of dominance in markets, which can take the form of standard form contracts in network and digital markets. Section 4 of the Act does not permit dominant firms to impose unfair or discriminatory contract terms while selling or buying goods or services. The Competition Commission of India has intervened on several occasions when dominant firms such as online portals and e-commerce service providers utilized standardized terms while imposing conditions of exclusivity, utilizing deep discounting strategies, or providing discriminatory access to services. For example, in the Make My Trip and Go IBPO case, the CCI examined the practice of online travel agencies using unfair contract terms at the expense of hotel partners. The CCI may order a change in such terms impose penalties, or even ask for structural changes, thus ensuring fairness in contractual transactions within highly skewed markets. In addition, there are curative provisions in the Specific Relief Act of 1963 for the aggrieved parties in the case of their unfair terms of contract. The Act allows intervention by courts in the shape of rescission, rectification, or enforcement of contracts specifically. Especially in the case of the terms being unfair or fraudulent, intervention by the courts is possible. For instance, where a person is deceived into signing a standard form contract with burdensome terms, the court may order rescission, that is cancellation of the contract, or redraft it to reflect a balanced agreement. In electronic transactions, the Information Technology Act of 2000 applies, especially in the cases of click wrap and shrink wrap contracts, where consent is usually presumed and not bargained. The Act does not cover the general reasonableness of contracts, but Section 10 capital A acknowledges electronic contracts and hence brings them under the general provisions of the Indian Contract Act, such as free consent and legal consideration. Where electronic platforms employ standardized contract to impose unfair terms, such as rights of unilateral determination or exclusions of liability, such terms may be challenged as void under general principles of contract law, especially where they contradict consumer protection legislation. Now, let us talk about the emerging issues and challenges. The topography of standard form contracts in India is being fundamentally reshaped by technological innovation, the digital revolution, and increasing economic complexity. Though standard form contracts have been useful tools of business transactions for decades, these new forces have created new challenges to enforcing equity and the problem of reasonable remedies. One such problem in modern society is the prevalence of digital contracts, that is, click wrap, shrink wrap, and browse wrap contracts over online transactions. Such form of contracts have the potential to coerce consumers into giving consent to burdensome terms and conditions by merely clicking an I agree button, or even by the mere fact of use of a service. Such a method of agreement raises fundamental questions regarding the quality of informed consent. The vast majority of consumers do not read or understand the conditions, which are typically drafted in cryptic legal language and verbose styles. The very nominal vagueness of such contracts undermines the long-standing doctrine of free and informed consent, rendering it challenging for courts and regulatory authorities to determine the voluntariness of agreements and reasonableness of contract terms. Additionally, the inherent non-negotiable nature and take it or leave it feature of such contracts increase the risk of exploitation, especially against consumers who have low levels of digital literacy. Compounding this problem is the role of artificial intelligence and contract automation. As AI technology increasingly does the work involved in contract drafting and signing, accountability, transparency, and the right of consumers to challenge unfair terms crafted by inscrutable algorithms have become pressing issues. The interface between AI generated contracts and consumer protection law is still in its infancy, and Indian courts have not yet made thoughtful responses to these questions. The change brought about by this technology is a real challenge to the existing legal framework, one which has long depended on the contraventions of human negotiation and understanding. Thus, it calls for a change in regulation to keep pace with technology developments. The second concern is the widespread presence of big players and websites with the potential of using standard form contracts to impose burdensome terms on consumers as well as small business partners. In some industries such as e-commerce, ride-hailing and gig economy platforms, contract terms are prone to include provisions that restrict liability, mandate arbitration or restrict user rights. The market power of these platforms is so great that it becomes in effect impossible to bargain or refuse unfavorable terms without being refused access to essential services. The subject matter under consideration brings concern of abusive dominance and unfair trade practices, both of which come under the ambit of competition law, subject to stricter provisions of consumer protection. The Competition Commission of India has attempted to that effect. However, the fast changing and emerging market calls for stronger and more stringent regulation. Furthermore, the widespread use of arbitration clauses in form of contract has been the cause of intense controversy and debate. Most standard form contracts require arbitration clauses to be the sole means of resolving dispute, which could restrict access to justice and its affordability for consumers and small enterprises. Even though the majority of arbitration is supposed to be a quick and less formal means of resolving disputes, procedural intricacies, expenses and perceived bias at certain arbitral centers could discourage meritorious grievances from being heard on an equitable basis. The Supreme Court of India has tried to protect parties from excessive arbitration clauses by making them subject to reasonableness and fairness. But it is a delicate balance between enforcing contracts of arbitration and protecting consumer rights, particularly where such terms are imposed in non-negotiable contracts. Another issue is also the absence of sectoral regulation and definition of unfair terms in standard form contracts. Whereas regulatory regimes in insurance and banking sectors with mandatory fair practices codes exist, most other sectors, particularly new age digital and financial services, have not yet evolved a mature regulatory paradigm. This gap in regulation provides room to be filled with unjust contract terms with no prepayment statutory sanction. For example, in fintech, where new products and services are emerging at a feverish rate, the consumer is constantly subject to unclear terms on data privacy, charges and liability with little statutory cover. This vacuum requires quick and agile regulatory intervention able to keep up with technological overthrow and market innovation. Last but not the least, consumer awareness and digital literacy are issues that cannot be overstated. Strong legislation will not be sufficient to overcome unbalanced standard form contracts, but it also depends on consumers being able to understand their rights and terms they sign up to. Large parts of the populace in India still lack good access to legal information and digital literacy, and thus easily are the victims of exploitation under sophisticated standard form contracts. Being ignorant, consumers will not be able to opt out of unfair terms as well as remedies, and thus the imbalance of power remains. Now let us talk about the recommendations and the way forward. First, codification of a harmonized legal code to address unfair contract terms in standard form contracts is the demand of the time. Whereas Indian law touches fairness in contracts briefly through statutes and judicial conventions, not having a statute like the United Kingdom's Unfair Contract Terms Act or the European Union's Directive on Unfair Terms in Consumer Contracts is better. Such a statute would provide explicit and specific guidelines. To take an example, tests of unconscionability, reasonableness and transparency, and it would be definite and more consumer friendly. Second, The regulatory authorities need to be empowered and incentivized to oversee and enforce in sectors where standard form contracts are prevalent, that is banking, telecom, insurance and e-commerce. The agencies need to be bolstered with precise mandates to substantiate standard contracts, bar predatory terms and penalize wherever the need is felt. Synergy between the regulation and the consumer protection agencies will lead to more efficient enforcement and act as a deterrent to exploitative behavior. Third, the courts need to develop uniform principles to ascertain the enforceability of standard form contract clauses such as arbitration and exclusion clauses, which are usually overlooked. The courts need to navigate a thin line between commercial freedom and justice to ensure that no clause is against the spirit of contractual agreement or public policy. Finally, but not the least, consumer literacy and online awareness are equally crucial, especially with more online contracts and AI contracts. Equipping consumers with the latest and reminding them to check contract terms can empower consumers more in the fight against unfair practices. So, to conclude it all, though standard form contracts are necessary in order to promote commercial efficiency, the inherent imbalance of such contracts raises natural questions of fairness and consent in India. Judicial standards, legislative safeguards and industry-based regimes of regulation impose important checks on unfair terms, yet loopholes do exist, particularly in these times of digital age. More legislative safeguards, direct regulatory supervision and prudent judicial vigilance are the need of the hour as part of a comprehensive approach towards consumer and weaker section protection. Clarity, justice and accountability in standard form contracts will bring in confidence and fairness, bringing India's legal framework in sync with global good practices and in tandem with the requirement of the modern era. With this, we come to the end of our today's lecture. Thank you very much.